Welcome to the latest episode of Called to the Bar, International Law Over Drinks. I'm your host, Dr Tamsin Phillipa Paige, Associate Professor at Deakin Law School. Today we are discussing the recent UK Supreme Court decision in the Scottish Minister's case and how the sweeping claims it made about trans people and the UK Equality Act sit against European Convention on Human Rights jurisprudence. In order to have this discussion, I'm joined by Matteo Bassetti, a PhD scholar at Essex University, and Manon Beury, a PhD scholar at Geneva Graduate Institute. Before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we should say should be taken to have been thoroughly peer-reviewed. I would also like to note that both of our guests are speaking in their personal academic capacities, and nothing they say can be taken to be reflective of the views of any of their employers or clients. And before we get down to business, our traditional first question, Manon, Matteo, what's your drink?
I am a very basic Italian, so I am drinking an espresso. Um,
Fantastic. Nothing wrong with that. Do you have a particular preferred blend of beans that you pick up for your espresso?
just like a very basic Italian brand. It's more about, I am quite specific about how it's made. So
Ooh, tell me.
I just have a mocha. I can't stomach coffee that is weak. Like I don't know, filter coffee and stuff like that. I'm like, so where's the kick? Like, how do I get my brain to work in the morning?
You and I are coming from opposite ends. I actually like my coffee through a filter rather than an espresso because espresso feels like I'm being punched in the face with coffee, and I'm not a huge fan of that.
I
So,
need the fun, otherwise my day won't start.
fair enough. Manon, what have you got?
So I get an Earl Grey tea, which is misleading because I'm not a tea person at all. But I already got a cappuccino like 40 minutes ago. So I thought that having a second coffee already would be a little bit too much coffee for a morning. I will wait a couple of hours for the next one. But so yeah, just a basic Earl Grey tea for now, just to get like this little punch of caffeine, but not too much.
Excellent. It's evening here in Australia, and we are set for it to be the first overnight of the year where it's going to get to negatives where I live. So I have a Sicilian orange hot chocolate from Grounded Pleasures. So that's kind of warming me up as we start moving into winter. And as a traditional first question for guests who have not been on the pod before, we like to kind of discuss how we got to know each other. So, Matteo, as noted in the Space Law episode with Chris Van Eyck, you and I met in Melbourne at the Kill 2 workshop in 2022, where you presented what became an excellent chapter on the pathologization of trans people and as it relates to the right to life. How does this meeting look from your perspective?
Yeah, it was a really nice way of meeting each other. I'd heard about you from Chris, of course, and really good things. And I think that, yeah, at the workshop, I presented a chapter that left me like super vulnerable. And so I think I was really amazed by how welcoming you and Claren made it. And yeah, I had just started my PhD, honestly, like a month before. And the only problem with that is that now you set a bar super high to what an academic workshop can be. And so I often go into places and I'm like, you can do better. So yeah, it was an amazing start to my PhD. Yeah.
Fantastic. And Manon, we first met in Luxembourg at the Max Planck Institute during the workshop for the Oxford Handbook on Women in International Law, which from my perspective was a workshop that saw me spend a lot of time telling anti-trans scholars that their argument was hate speech and we don't need to engage with that. Where you and Juliana Santos de Carvalho presented a paper on the Vicky Hernandez judgment in the Inter-American Court of Human Rights, specifically focused on Judge Elizabeth Odio Benito's transphobic partial dissent. We've stayed in touch and since then, and most recently had coffee when Ansel was in Melbourne in 2024. Do you want to tell the story from your perspective?
Sure. So actually, the first time I saw you online was earlier than that.
My
It
mistake.
No, it's okay. I think for you, I was just one of the people in the online audience, but you moderated a panel in the virtual queer method workshop that we co-organized with Lena Holzer, Berenice Schramm, and Juliana in 2021. And I remember that you had this amazing hat. And so during the moderation, and so that's the first time that I saw you, and then I kind of started following you on X Twitter and follow your work. And indeed, I was really lucky to meet you in person then a year later at this workshop in Luxembourg, which was really complicated for me and for a lot of, I think, let's say, queer and more critical scholars. I guess in this.
Yeah, it had some good moments, but there was a lot of as I remember being the most senior queer scholar in the room and having to do a lot of standing between anti-queer, liberal feminist scholars and the more junior queer scholars because it was not great.
I think I get back to Matteo has just said. I think maybe we're a bit spoiled as queer scholars because the conferences and the academic spaces that we navigate are so caring and sensitive and non-hierarchical, and so all of a sudden to be in a normal workshop, I would say, uh, was quite complicated. And with Juliana, we came with this paper that was very critical, as you said, of Judge Odio Benito's partial dissent, and we ended up in a panel that was moderated by a very senior and well-regarded judge, human rights judge, who was basically defending her good friend, Judge Odio Benito. And I also can understand that, but saying that we did not understand her dissent. And so, as junior scholar who don't even have a PhD yet, being confronted to this very senior people and having to defend yourself in front of an audience of I don't know, probably 30, 40 people who are all more senior than you. It was complicated, and there were a lot of minor humiliations on top of this. There was a dinner, and when we arrived with Juliana, they did not put us at the table with everyone else. They put us at the table on the side, just the two of us. These kind of things. It was not easy, and I really appreciate it because you created in the middle of this this bubble. You were really present for us, and I remember that we had a wonderful dinner the second day with Odette, you and Juliana, and we could really. You managed to bring these queer methods into this traditional law workshop, and that was really wonderful. And indeed, then we met in Melbourne. So I spent 5 months in Melbourne last year. Yes, last year. I got a scholarship to do an academic research there, and we met during ANSIL, and you gave me some very precious advice over a coffee. I really appreciate. And I want to also to point out that it's the first time that we meet with Matteo, I think, although I've been following his work for a very long time. Actually,
It's the other way around.
Yes, because you couldn't make it to Australia for the Kill 2 workshop, even though you have a paper in the books, because you were stuck I believe you were stuck in France at the time. And so you just presented online so that you and Matteo never actually crossed paths at the workshop.
No,
Yeah.
it's the first time, and thank you for giving us this opportunity. Matteo, your paper on human rights bodies adjudication of trans people actually came out at the very beginning of my PhD. So I think that I started my PhD just a few months earlier than that. So when I just started my first literature review, I came across it and then kind of followed you from afar since then. And our paths crossed, but we never met.
Yeah, it's quite impressive how we got really close a few times, and it's really nice to finally meet.
Yeah. Well, and our other traditional question for first-time guests on the pod is, how did you get into international law and how did you get to where you are presently as international law scholars?
So I think I first started being interested, like international law first entered my kind of like periphery of vision when I was in high school and Italy started being really bad at pushbacks of migrants in the Mediterranean. And then I was like, oh, human rights is an interesting thing. It's an interesting concept. And then started getting into it. And that's kind of how I ended up doing my bachelor in the Netherlands at Leiden in an international law interdisciplinary program. And I kind of like started from there. And then I really got into trans rights and queer approaches when I was doing my LLM here at Essex in 2018-19, and Emily Jones assigned, I was teaching there and assigned had a session on like queer approaches to human rights slash LGBT rights, and assigned some readings, and I was like, I disagree with it. And we entered into a really interesting conversation. At the end of the day, looking back, I probably agree with what she assigned, but in the moment, I was like feeling intense about it. And so we ended up having this like super interesting conversation. It was maybe the first time that I felt that level of engagement. And then I was kind of early in my transition slash in this very strange moment of gender. And I remember we had an exam. This is the stupidest reason why to get into trans rights, but we had an exam. It was like we needed to kind of like, it was like a case type of exam. And then I was like really bored, I don't know, one evening. And then I tried to use my transition to-do list as an example of like how does human rights law apply. And what I came up with was very different from what the jurisprudence or literature said. And that's how I ended up writing my LLM dissertation, which ended up being that paper that I published, and then at some point it also became it's becoming a PhD. I don't know. It's probably like a bit too personal, not very healthy. But that's how I ended up doing it.
Awesome. Yeah. Manon, how about you?
My path is a bit like torturous, but but eventually I got there. I come from France, and I grew up in a family that was very far from international law. Like none of my parents got their high school diploma. My mom stopped studying at 13. She works in a theater. My dad is a fishmonger. So like there really no. We did not even leave France. Like it was, when we would go on holiday, we would go like on holiday in France. And so, no, I didn't really know what to do. I had this big dream as a teenager of becoming a journalist, but like not any kind of journalist, like a kind of like super megastar international correspondent. And I think that's when I started to look at more like international things. And eventually I studied law. I didn't really know why. I think like a lot of people when they started to study law, especially in places like in France where university is free and you can actually try different things. So I studied law for 3 years. I hated it. Like, it's not that I hated it. I liked the perspective that it gave me on understanding society, which is kind of what drew me there in the first place. But my idea was kind of to take so in France, in order to get into journalist school, it's like competition. France loves competition. Like it's an exam and then you get ranked and you could get there. But at that time, so it was like late 2000, and it was the beginning of these 24/7 news outlets, like news. how do you call it? Yeah, just like constant coverage on TV, like this news broadcasts and stuff. And I really didn't like where like this journalist world was going, and so I decided eventually not even to go there. It disgusted me a little bit. So but I wanted to stop law. So I did a master first in international relations, and at the same time a master in European studies. And for this, I went to Belgium. In the meantime, I met my wife, and I think that she comes from Germany, and she really opened my perspective into like leaving France and maybe trying to like go abroad to study, especially because I didn't really find a master that really interested me in France. And so I stepped a bit outside and I went to Belgium. And then I did a traineeship at the European Union, at the European External Action Service, where I actually worked in the legal affairs division. And so I did only public international law, and I loved it. I was working on like Russia's annexion of Ukraine and public international legal aspects of migration and stuff like this. And I really loved it. And so I decided to continue my study and to do an LLM in public international law at the University of Leiden. So Matteo, hi. I was also at Leiden University. And then after this, there was a long period of like a long, quite tough period where I was going basically from one unpaid internship to a very poorly paid research assistant job to, yeah. So I did like a lot of small gigs, a lot of internships, and I worked in bars and clubs at the same time. And then I got a job as a teaching assistant at Leiden University, and that was the beginning of my academic career. I really liked it. I decided to do a PhD, and at this, I actually worked with Kees van Dijk, who is a professor on comparative sexual orientation law at Leiden University. And it's basically when I decided that instead of doing LGBTQI activism on one side and studying law and doing law on the other, I could bring both of them together. Like until then, and I think I was 25. Like I never thought about it. Maybe more. I think it was actually 27 or something like this. Like I never even thought about it, that it could be like compiled. And so yes, that's when I worked on a PhD proposal. And at that time, I was really outraged by what was happening with the anti-trans narratives and the gender critical movement in the UK that started to also get to actually other Western European country, to Australia, to and then when I started studying, I realized that it was even broader and that it would also go to the global south, and I really didn't understand why there was not a stronger movement against it, even from cis women, and that this actually affected all people and especially women, all women. And so yes, so I decided that I would do my PhD on this. I moved to Geneva, and a few years later, I actually got a job at the Office of the High Commissioner for Human Rights. Now I'm in this weird period where I'm working full time at the Office of the High Commissioner for Human Rights. I have a baby, and I do my PhD when I have time, which is not very often. And in the meantime, as I told you earlier, I had the huge opportunity to go to Melbourne to study with Diane Otto, so to do research under the supervision of Diane Otto, which was absolutely wonderful.
Di is amazing. She's just, I think there's not a person in the queer international law community who doesn't have amazing things to say about Di and stories about how she has been kind and wonderful to them. So yeah, absolutely, that going and taking that opportunity was the right decision. So yeah. Okay, so on to our main event. So on April 16, 2025, the UK Supreme Court decided the Scottish minister's case, proclaiming that, among other things, the Equality Act 2010 UK means biological sex when it uses the word sex. So what it really means is sex arbitrarily assigned at birth. that sex only has one meaning, which I'm honestly waiting for incels to try and use that argument about how aggrieved they are about not getting any, and that lesbians are people assigned female at birth, attracted to others who are assigned female at birth, which tells me that the judges have never met a lesbian because there isn't a group that is more supportive of trans inclusion than lesbians. So, this has led to the UK Equality and Human Rights Commission issuing guidance that the exclusion of trans people from society is now required by law, and that the FA banning trans women from playing community football. I'll also note that this has also recently had, before this occurred, all of the US Golf Association and the RNA in the UK are banning trans women from all golf competition as well. So, my question to both of you, as the experts in this area, what's this case about? How did we get here? And what's the judgment doing?
Wow. I think it's important to understand that this case is about erasure of trans people from public spaces, that it has nothing to do with women's safety, even though it tries to frame it that way. And that's like, for me, the most important basic understanding. Because when the court goes through its reasoning, it then fails to actually demonstrate anything. That's like, I think that sometimes it becomes a bit confused. The second part that, especially in the public discourse and commentary about this case, gets very confused, is that this case is about the Equality Act and it's not about access to spaces, right? In theory, how it's been interpreted and how it's been applied is very different. But my understanding, and I am not a UK lawyer, I do not study UK law, I only happen to do a PhD in the UK, is that the case is about whether service providers and institutions are allowed to exclude trans people from single-sex spaces, is not about them having and being required to exclude trans people from single-sex spaces. And I think that there are some really interesting analysis by queer and trans scholars about the actual case, like paragraph by paragraph, that I'm not able to do. But I think the problem right now is that the public discourse and the Equality Commission are making this case about something that it's not. They're saying that service providers have an obligation to exclude trans people from single-sex spaces, while the case does not say that. The case never said that, but what it probably will end up happening is unfortunately that. I think that's it. Yeah.
No, definitely. And when you say that the case is not about that, it's actually what I find interesting is that the case very rarely mention what it was about at the very first place, which was actually a challenge against a Scottish guidance authorizing the inclusion of trans women when it comes to positive action measures. And so actually the case focuses a lot on single-sex spaces. But at first it was about the application of the Equality Act in a guidance on positive action measures. And actually I also want to emphasize that this will also be another consequence of the case. So that means that whenever an employer or some like a public authority has positive action measures for women, trans women will actually not be able to enjoy them.
The actual positive action measure was counting trans women with women on board quotas, corporate board quotas, wasn't it?
That's it. So it was
Public board.
about the Scottish Act on Gender Representation on Public Board, which requests that 50% of women are appointed to non-executive posts in public boards. So that was really like what was at the core of the case, and actually the judges in first and second instances said that the law is very clear and the Equality Act is very clear, and trans women of course, trans women with a gender recognition certificate, so who have legally changed their gender, could benefit from these measures because they are legally women. And that's where the Supreme Court, in unfortunately unsurprising turn of events, when we look at the general discourse, anti-trans discourse in the UK, decided that in fact women should not be trans women should not be legally recognized as women in the application of the Equality Act. Once again, it didn't say, like a lot of newspapers like cited in their headers, that the court said that trans women are not women generally. Although, when you look at the case, trans women are actually constantly referred as biological males, or even at one point, or like in one or two instances, the judges even write that trans women are male identified as women. So I would say that legally it does not say that trans women are generally not women, but the judgment definitely feed into this narrative for sure.
Yeah, and I think when I was reading the case and I was and that issue about language came up, the case of Api Garçon and Nico versus France at the European Court of Human Rights came to my mind, because that case misgenders the applicants throughout the whole case, and so I was like, it was kind of a flashback a bit. And I think that one issue that really came up in the case is that that of legal gender. What does legal gender recognition mean in the UK, right? For the interpretation, like before this case, under the kind of category of sex, there was like trans people with a gender recognition certificate were understood as belonging to their affirmed gender. But in the UK, very few people have a gender recognition certificate, because a gender recognition certificate is a profoundly pathologizing process, and is a very complicated one that takes several years. And you can have a passport with your affirmed name and gender without having a gender recognition certificate. So there was this kind of like dual system where, yeah, very few people have a gender recognition certificate, and a gender recognition certificate, for example, asks trans people to undergo what we call a real life test. So you have to have lived in your affirmed gender for at least 2 years and have a whole bunch of medical documentation. So it's a very dehumanizing process to begin with. And then the court really obsesses about, how do we recognize trans people who have a gender recognition certificate and trans people who don't have a gender recognition certificate, right? And they go into this whole reasoning of like, oh, but we can't ask people to give their birth certificate when they try to access a toilet. And so it kind of like shifts the focus on this idea of, it would be unfair for trans people with a gender recognition certificate. Like, it goes into this whole strange reasoning about, oh, but then we can't treat trans people with a gender recognition certificate differently from trans people without gender recognition certificate. And then it says, well, you know what? We're going to discriminate everybody. and make a gender recognition certificate basically useless. And so it's like, yeah.
Yeah.
I had to read the case a few times, and I still don't think I fully understand it.
And so, I mean, that kind of gives us an idea about what the case is about and what it's doing. And what it's doing is rampant discrimination. And Manon, you've already kind of touched on this. How did we get here? How did we get to a point in public discourse where we are having case judgments come out like this?
Yes. So indeed, like this judgment doesn't come out of nowhere. The transphobia and transphobic discourses are very prevalent in the UK. And actually, I think that it's quite telling that several human rights mechanisms before this judgment have already singled out the UK for its transphobic discourse in public discourses, notably in the media, but also by politicians. And I think academia also has a responsibility, to be honest, there. So, for instance, there is a resolution of the Parliamentary Assembly of the Council of Europe that I think it's about basically hate speech against LGBTI people, rising hate against LGBTI people in Europe, something like this. And they single out the UK next to Hungary, Poland, Turkey, and Russia. So, like, that's
There's a
group.
group you want to be
The
associated
UK is
with.
not, yes,
Yeah.
not glorious, right? In terms of LGBTI rights. And there was also a visit of the independent expert on sexual orientation and gender identity. There is also a 2022 report of the Commissioner for Human Rights of the Council of Europe that has like a few pages on this. So there is really, I think, a specificity in the UK that can also be seen in the US to some extent. But I think the US does not really have the same culture than Western Europe when it comes to freedom of expression and so on. But it's really unleashed in the in the UK compared to the rest of Western Europe. It's called sometimes Turf Island, and for good reasons. And I think Matteo being there, like I don't go to the UK that often. I have some friends there, but what what I read is mostly on in the media. But I understand that like several people have told me that in the past, let's say 5-6 years, it has become more and more difficult to be an openly a visible trans person in the public space in the UK, which also means that there is this threat of harassment, of violence, of discrimination, of being targeted both online but also in person, which means that in such a threatening atmosphere, I come back to what Matteo was saying at the beginning, there is already and there will be a tendency for trans people to just stop being publicly visible and to advocate for their rights, of course, because when you're under such threats, it's very difficult to keep fighting for your rights. So I'm very concerned that this judgment for sure will increase this tendency even more, and that's very, very concerning.
Yeah, and I think that on this, one thing that is really interesting about the UK, but I'm not sure it singles out the UK so much, is the idea that trans people's voices are unreliable. So in the UK, when trans people speak about our lives, our experiences, there is, in most situation, a setting of debate. Very rarely trans people are allowed to speak without having an anti-trans counterpart. And this you can see also in Italy and in other countries. But in the UK is kind of to the extreme, also because the anti-trans counterpart is extremely well-funded and organized.
Yeah, J.K. Rowling's billions being put to good work there.
Yeah, absolutely. So I think that this is like, but this also creates this narrative of trans people cannot be trusted. And it all stems from the institutional pathologization of trans people, because if the state says we're mentally ill and we require to go through all of these like psychiatric tests in order to be trusted as trans people, trusted in our own judgment of our identity, then this also transfers into the public discourse and into the idea of trans people cannot be trusted. Trans people cannot be, it is also okay to give voice to someone other than trans people and to exclude trans people from discussion about our own rights. And I think that one thing that we haven't mentioned yet in the case is that trans people were never heard. Trans people were not allowed to intervene as third parties. Two, three anti-trans organizations intervened as third party, and no trans person or trans organization was allowed to intervene. And there has been a lot of discussion about that in queer legal circles, about how this case not only is wildly discriminatory, but also has a whole bunch of procedural issues that were shocking to a lot of legal commentators. And how this was allowed because of kind of like already ongoing dehumanization of trans people in the UK, also in previous legal cases, right? Like this is not the first widely discriminatory case in the UK. There have already been a whole bunch of them.
And not only did the court only accepted interventions by gender critical organizations, but also it used them a lot. Like actually the whole case is based on the arguments provided by these interventions. And there is even a special thanks to the lawyer of one of these organizations, who was also the lawyer representing like other very prominent cases, defendants in cases regarding anti-trans rights. Let's say it doesn't make any sense. Anti-trans cases. So, and like the judgment really makes it clear that its argument is based on these interventions, and in this regard, it's really outraging that they have not heard from a single trans rights organization. I think the only organization that could that could submit an intervention is Amnesty International. And actually, their intervention is mentioned in one sentence in the whole case, just saying they have submitted an intervention. That's it, nothing else. And then the other ones get dozens of pages. So I think that's very shocking.
Yeah, that is interesting, and I'll get to why in a minute, but I have one last question before we move on to the European human rights discourse and its comparison. Manon, you mentioned earlier that all of these anti-trans rights campaigns also have serious repercussions for cis women and cis women's rights. How does this judgment and that idea generally come about? How does it feed into that issue?
I mean, it's from the very first paragraph of the judgment, we see that the court is decided to pit cis women on the one side and trans women on the other side as two groups that oppose each other. And then there is this whole, like basically the whole case is about the definition of sex. What is sex? And take, and the argument that, at least in the Equality Act, but let's say legally, sex should be read as being biological. And we know that the meaning of sex is actually, contrary to what the judgment said, not that clear at all. And I don't even have time here to go into issues of intersex people, obviously, and sex characteristics and so on. But it is interesting that the judgment does not even mention it, because it's actually, I think if we talk about biological sex, any discussion that does not at least mention intersex people is clearly baseless. But even without going in this direction, it's interesting that the court takes two main examples to explain that in the Equality Act, the meaning of sex is biological sex, and the first one is about reproduction. So the fact that women, and I put like quotes there, are allegedly supposed to be able to give birth, and the fact that lesbians, as that you mentioned earlier, are of course attracted to women because of their biological sex. And so firstly, not all women, like cis women, trans women, have the same reproductive capacities. So this like essentialist visions, it's crazy that these essentialist visions of women that the court is really basing its argument on are actually what feminists have been fighting for 70 years or more. And nobody says anything about that. So all like these feminists in the UK that are welcoming the judgment are not even pointing it out. And also, just a side note, but if the court would have listened to trans people, maybe she would have known that, for instance, some trans women are able to breastfeed, for instance, which is one of the arguments that they use. And then regarding lesbians, as a lesbian, I take offense. So because the court spent a whole, like, there is this whole section that is extremely long and like it's impossible to understand, and comprehend it, on why lesbians are actually attracted to women because of their biological sex, and which does not make any sense. And as you said, this is not grounded on any evidence, because all surveys and so on show that lesbians are actually the group, let's say, if we have to categorize people, that is the most welcoming to notably trans women and just trans people in general. But of course, when you only listen to trans exclusionary LGBTI group, where there are not so many lesbians, you will not know that. So and then my last point, and that's probably one of the most important one, is that regarding discrimination, the court says that discrimination against women, like as a group, is actually linked to the shared biology of this group of women. Of course, when I say women here, it's cis women, obviously. And that just goes against all, not only feminist understanding of discrimination, but also the definition of sex discrimination in international human rights law, not only even in European human rights law, but international human rights law. When you look at the definition of CEDAW, for instance, and the general comments of the CEDAW committee and so on, like, actually, it's pretty clear that it's very clear that sex discrimination is about patriarchy and about gender roles that are like forced on women as a group, and not about their shared biology. But the court decided to completely disregard this point.
Yeah, that's a problem. And I'm going to kind of, Matteo, you mentioned the whole we can't check birth certificates at the bathrooms. Do you want to expand how that's going to lead to building on Manon's comments about how this is going to hurt cis women as well as trans women?
Yeah, I think it's going to lead the practical effects of this judgment is that, for example, I, as a trans man who is not visible as a trans person, I'm not visible as a trans person. I am not going to be kicked out of bathrooms, right? But a gender non-conforming woman probably will, right? So like it's all of this. I don't know, at some point I was reading the case and I was like, okay, this is like there is all of this wrongness in how it's framed that is really hurtful. But then also there is the practical side, right? I was thinking about my community at uni, right? At the university, it's a campus university. What are the practical steps that I need to go through, right? In order to make sure to help people navigate this space with some sort of safety, right? And what is becoming clear is that all of this is going to just result in the harassment of any and all gender non-conforming individuals, independently from how they identified. Are they trans? Are they butch? Are they queer? Are they gender non-conforming? However they identify, whether they have undergone gender affirming treatment, whether they have not undergone gender affirming treatment, is going to be about, in the split of a second, can someone think that something is up with your gender? Is someone going to feel entitled to police your gender, to challenge your presence in a bathroom, right? On some parallel note, I I personally started being challenged in public bathrooms like as a teenager, even before. And the vast majority of my challenges in bathrooms were way before I identified as trans, right? And I can relate to a lot of people who are going through this, right? So yes, I think that that's like a very practical consequence, is going to be a very practical consequence of this. And then another thing that I think really about all of the whole pregnancy and reproductive side of it, I thought about it, is that one of the few instances where the case considers the existence of transmasculine people is trying to say that pregnant transmasculine people, pregnant trans men, would not be protected under the pregnancy provisions of the Equality Act because they would be considered men, right? If we were to take a certified sex approach. And I found it extremely enraging how the court addresses this issue and how the court discusses the case of McConnell, like Freddie McConnell, which for me, I don't know, like for me, I was following the case and the story of this trans man who got pregnant and has two children, and who also had made a documentary about it. And for me, it was a very restoring story because in Italy, the state forced trans people to undergo sterilization until very recently. And so I grew up with the idea that you're not allowed, you're not able to have children, to have a family. And so this idea is, yeah, I find it very dehumanizing, and to use this gained freedom to undo the case and to further discriminate, there is something really perverse about it that I don't think I have the words, or I have not processed, or this how this argument was made enough to go through it. But I think that, maybe jumping a bit ahead of the queue of questions, I think that the European Court of Human Rights jurisprudence really facilitated this perverse use of pregnant trans men, because in a recent case against Germany, it of a pregnant of a trans man who had given birth, and wanted to be recognized as the father of his children. The court said, "Oh no, margin of appreciation," and refused to judge on this. Refused. Well, no, I mean, it just said, like, no, there is no violation of the right to private life. And I think that human rights bodies are starting to face this possibility for the first time now, because until very recently, trans people were massively sterilized, and now we're starting to have kids. And so, yeah.
Yeah,
Sorry,
and
I
before, no, that's okay. We're going to move on to the European Court jurisprudence in a second. I just want to say the other area where I think there's a real problem with the judgment in terms of discrimination is the disability rights, because the response from everyone has been for trans people to just use accessible toilets, and that's going to cause a real problem for disabled people who need accessible toilets for accessible reasons, having to then not have access because trans people who don't need the accessibility facilities are being forced into these facilities too. So that's the other area of discrimination that I'd kind of seen from the case. So you've already started our conversation about how this compares to trans rights in the European Convention and the European Court of Human Rights. Let's how does this compare? I mean, moving on, we've already mentioned that one case around the trans man being refused recognition as the father of his children. How does it compare more generally to trans rights in Europe?
So, to some extent, I want to point out that UK was mostly, until now, the UK was mostly in compliance with international human rights law, but not fully. The Gender Recognition Act that allows trans people to have access to gender recognition certificate and legally change their gender on their birth certificate, notably, as Matteo pointed out earlier, exists. Like this possibility exists, but there are extremely long delays. It's a pathologizing process. The UK was one of the first countries in Europe to introduce this possibility, but we can see that the law is quite outdated today. And actually, the European Court of Human Rights insisted that legal gender recognition should be accessible, quick, effective, and transparent. And it's not the case right now in the UK. But it exists. And now the issue is, will it continue to be effective today, when you see that trans people who have got a gender recognition certificate are still legally treated as belonging to their sex assigned at birth for a very large, probably very large variety of issues. So that's one of the questions, I guess, about the conformity with European human rights law. And
I think,
yeah,
if I can add one thing about, I think, the UK and the European Court of Human Rights and legal gender recognition, is I think it's really important to note that the UK has illegal gender recognition because it lost a case before the European Court of Human Rights, right? And I think this is like a key part of the whole narrative, right? without that case, I'm not sure when the UK would have gotten legal gender recognition, right? So the UK actually introduced legal gender recognition quite late in 2004. It was one of the first countries to introduce it without the requirement of sterilization, right? But it introduced it because it lost a case. And there's a weird little fun fact. And I think that like the UK, one of the key arguments of the UK Supreme Court case is that it's this interpretation of a Sex Discrimination Act from 1975. And they say like, it's always been interpreted as meaning only biological sex, blah, 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 la, la, la. But then the UK government in Goodwin versus the UK actually tries to say this case should not be heard before the European Court of Human Rights because the 1975 SDA actually includes trans people. So I don't know. I was like, okay, yeah, lol, you're definitely like using things in a very narrow way. And then yeah, like the one thing that the European Court of Human Rights said in 2002 in Goodwin versus the UK is once you have a legal gender recognition, it needs to cover all aspects of life. And then there is the exception about parenthood. That's like another case, right? Like it says you need this is one thing that the European Court of Human Rights has said consistently on trans rights. On everything else, questionable jurisprudence. But on this one, it has been consistent since 2002.
A very important argument for the European Court of Human Rights to apply this consistent case law on legal gender recognition is actually that the court find it profoundly dehumanizing for trans people to have to disclose their trans status, and it's something that comes up in like basically all case law about trans issues since 2002. It's that being forced to disclose a person's trans status is actually against the principle of human dignity, against the right to privacy, against personal autonomy, and the court, the Supreme Court, kind of tries not to go there in a sense. So there is this whole discussion about, oh, but we cannot force someone to say that they have a GRC. But in practice, when we think about quotas, for instance, like when we think about positive action measures or something like this, how, if it's so-called biological sex or sex assigned at birth that is to be taken into account, I'm afraid that in practice, in some instances, people will probably have to disclose the fact that they got or did not get a gender recognition certificate. So I'm not sure. I don't know, Matteo, what you think about that. But that was one of the issues that came up when I read the case. I was wondering about this disclosure.
I mean, I think that in practice it's going to come down to visibility, right? Because all the purpose of the gender recognition certificate is to make it impossible for others to know that someone has obtained a gender recognition certificate. So what the gender recognition certificate does is it issues a new birth certificate, right? So unless you're visible, actually, like bathroom police is not going to be able to know that you're trans because that's the whole purpose of the gender recognition certificate. So there is an impossibility of application of this, right? That is like very clear and very present. And then,
Yeah,
I think that's my main thing. Like, I don't understand the how, right?
And yeah, so what I'm hearing is that basically the entire judgment is deeply inconsistent with European court and convention rights for the most part, aside from these parenting ones that you've already mentioned, Matteo.
Yeah, it totally goes against the case law, and it only mentions Goodwin versus the UK once, say, like, or twice. And I find this like wild.
And basically, what the European Court of Human Rights say is that, in general, the rule is that there should be no interference of the state with regard to the the fact that trans people get legal gender recognition for all purposes, and there can be some exceptions. It's the same as I would say that it's the same as for equal treatment as well, which is also an issue here in this case. The rule is equal treatment, but there can be some interferences of the state, and those should be the exception, and there should be proportionate and pursue a legitimate aim, right? Like that's the basic human human
So
rights application. But here we have, like, basically the court reverses that. It's
yeah,
like the exception becomes the rule, and then and even if it's not mandatory, at any point does the judgment like convincingly explain it's why this should be reasonable, proportionate, and pursue a legitimate aim. It does not really enter in this discussion. It just focuses on biological sex and the meaning of sex.
and I think that that means that I know that there's been at least one request for an appeal to the European Court of Human Rights lodged so far on procedural grounds of a former judge in the UK who's trans has lodged an appeal on procedural grounds. I have a feeling that this means that we're going to be having to have a follow-up episode after the European Court has a decision.
If I can add one thing, is that it's all nice and good, but the European Court of Human Rights has been quite bad on trans rights. Like,
I'm aware.
let's not forget that the European Court of Human Rights has been bad about trans rights, and I think that its failure to address trans rights as human rights is one of the causes of this, right? For the past 25 years, the European Court has said that someone other than trans people can determine whether someone is sufficiently and adequately trans. So the profound institutional pathologization, the fact that it never challenged the authority of someone else to decide whether you're trans enough, is actually the same mechanism that is at the basis of this judgment, right? Because it has never said that trans people have a right to legal gender recognition and to live in our gender on the basis of our self-determination, right? And this judgment is just an extreme version of the same paradigm, right? So the public discourse that has come out of the European Court of Human Rights is a judge, a psychiatrist, an administrator can say that someone is not trans enough to access a service, to access a medical treatment, to access a single sex space. And this UK Supreme Court case is expanding this beyond reason. But the problem is human rights institutions have failed to say trans people have a right to live in their gender just because they identify as such, and without having to undergo humiliating medical treatment, psychiatric assessment, being challenged in their understanding of their identity. And I think we shouldn't lose sight of this problem, like of this issue of disempowering trans people and giving the decisional power to an external authority.
Completely agree. Yeah. And so while we may hope for a better outcome from the European Court, it's still grounded in the same pathologization paradigm that you have well argued is a violation of the right to life. And
And
Manon, did you want to make one last comment before we move to our wrap-up question?
yes, thank you, Matteo. Like in addition to the pathologization and so on, I also want to point out that the European Court of Human Rights is still struggling with a lot of concepts that the UK Supreme Court is also struggling with in the document. So when it comes to discrimination, like regarding legal gender recognition, I think the case law of the European Court of Human Rights is quite clear now, but not perfect, but quite clear. But with regard to discrimination, it's definitely not. And actually, the court is really struggling, for instance, to find which comparator is like relevant when it's about comparing the situation of trans people against another group to determine discrimination. And that's also something that the UK Supreme Court like struggled with. And with regard to the meaning of sex and so on, like it's still something that the European Court of Human Rights has not really clearly defined. With regard to using gender identity or sex as a ground of discrimination, whether trans people can be discriminated on the ground of sex, it's quite inconsistent. The case law of the European Court of Human Rights. So I think the cases to come, because there will probably be cases for sure, whether the one that has been lodged now will actually make it to the court of, or now there will be cases for sure in the future, and it will be quite interesting. And I honestly I'm not sure which way it will go. I think it's really difficult to know right now.
And on that bleak note, let's move on to our wrap-up questions. So, our final wrap-up question, to move away entirely from international law, who is one of your favorite obscure or underrated characters in fiction, and why do they speak to you?
Manon, you go first. I have to think about it.
Okay. So I decided to pick the first character that directly came to my mind when I saw this question, and I think I want to say that it's. I don't think that it's an obscure character, but it's underrated, and it's Lyra, who is the main character of the trilogy of fantasy novels, His Dark Materials. And so these novels were published like in the 90s, 2000s, and they take place across a multiverse. And Lyra is like a very brave teenage girl who is like navigating across universes. And but really it's about like how to navigate a men's world, and it's also about the religion dogmatism. And it came to my mind because I think that it's time to stop financing J.K. Rowling. And also, although we all absolutely love Harry Potter, I do. I grew up with him. I think it's time, really like time now. It's been years to detach ourselves from like can we say piedestal? It's a French word,
Yeah,
like to to the very high regard that we've put Harry Potter on, and discovered that there are a lot of coming of age stories, that novels, fantasy novels for teenagers and children that are amazing. And His Dark Materials is one of them. And please offer His Dark Materials to like your children and not Harry Potter.
I would agree. I am at the point of, if people say that that they just want to continue consuming Harry Potter, I'm like, what you are saying is you don't care about the queer community, and that's my thing. And I would also add, as a series, as an alternative, pick up Gail Carriger's Parasol verse and start with the YA ones, which starts with etiquette and espionage, because who doesn't love a teenage girl learning to be a spy while throwing herself around a steampunk airship in Victorian England with vampires and werewolves?
Wow, I love
I do.
that.
Matteo, your fictional character.
I had completely missed this. So I was just trying to think for like, half a second, and I think I'll go with also like my childhood escape strategy. I was absolutely obsessed as a kid with Pippi Longstocking,
Can I just
and
add an interjection here? So my middle name's Philippa, and I am known and have been known my whole life because I'm very tall as Pippi Longstocking.
yeah, and I think that it was when I was a kid, it was the only version of being a girl that I could relate. And like all of the other kind of childhood representation where there's like super girly girls, and I was like, how? I don't understand, right? And this was like this kind of a bit gender non-conforming, but not really. But I understood it as a something that provided me this this alternative. And I think, yeah, I really liked it. It was this like hyperactive character that broke all social rules, and having the idea of you can break social expectations and social rules and not sit with your legs crossed and do all the pretty things is a way of being, and it is a way of doing gender. And that was maybe my first exposure to there are other ways of doing gender. So yes, maybe it's a bit
Yeah,
of an old type of
absolutely fine.
representation. Yeah, and I
Awesome.
think it relates a lot to the whole conversation that we had today about like what are also like the social norms and expectations that come to my mind.
Awesome. Well, that's all we have time for, and so thank you everyone for listening, and we'll catch you next time. Bye bye.
Bye.